3, 2, 1, ready, start. It does not appear to be to the intention of the Act to bypass the provisions of the other Act relating to the power of eviction, in as much as, otherwise, where a tribunal who is competent to pass a maintenance order, maximum up to a limit of rupees 10,000 cannot indirectly be empowered to deal with the property of a senior citizen, which may exceed many times the value of rupees 10,000, and in garb thereof the tribunal or authority under the Act of 2007 may enter into the realm of other regular courts and forum established by law, having jurisdiction over the subject matter. Stop para. Now, with the promulgation of the Act of 2007, if it is assumed that the tribunal or the district magistrate has the authority to order an eviction, then such power has to have some source within the Act of 2007, and only then it can be pressed into service, or else it will amount to an indirect method to achieve something which has not been conferred by the Act directly, and such an interpretation would not be desirable. Stop. It is true that the Act of 2007 is a social beneficial legislation for the senior citizens, parents, and it should be construed liberally in their favor, yet it also must be kept in mind that the rules of interpretation do not give right to the court to read into a legislation or a provision of the Act a power which otherwise is conspicuously absent, as shall be evident from the reading of the scheme of the Act and the rules framed thereunder. Stop para. It is now well settled that the courts do not legislate, rather it interprets the law. Stop. Even though, the Act of 2007 is a social beneficial legislation, but it cannot be lost sight of that the courts do not read something into the Act which has not been provided. Stop. It is the golden rule of interpretation of statute that the Act must be read in the manner with all the words and provisions, and to make it workable, keeping in mind that all the sections are given full effect and no provisions, as far as possible, is made redundant or superfluous. Stop. The court may be tempted to read something into the Act by invoking the doctrine of casus omissus, but even to do so, even in a social beneficial legislation, while taking an approach of purposive interpretation, there are guidelines, and unless the said guidelines are attracted, the court under the cloak of exercising the power of interpretation is not empowered to rewrite the law. Stop. In Union of India versus Devkinandan Agrawal, 1992, the apex court has held as under. Para. We are at a loss to understand the reasoning of the learned judges in reading down the provisions in paragraph 2 in force prior to November 1, 1986 as more than 5 years and as more than 4 years in the same paragraph for the period subsequent to November 1, 1986. Stop. It is not the duty of the court either to enlarge the scope of the legislation or the intention of the legislature when the language of the provision is plain and unambiguous. Stop. The court cannot rewrite, recast or reframe the legislation for the very good reason that it has no power to legislate. Stop. The power to legislate has not been conferred on the courts. Stop. The court cannot add words to a statute or read words into it which are not there. Stop. Assuming there is a defect or an omission in the words used by the legislature, the court could not go to its aid to correct or make up the deficiency. So, courts shall decide what the law is and not what it should be. Stop. The court, of course, adopts a construction which will carry out the obvious intention of the legislature but could not legislate itself. Stop. But to invoke judicial activism to set at naught legislative judgment is subversive of the constitutional harmony and comity of instrumentalities. Stop. Modifying and altering the scheme and applying it to others who are not otherwise entitled to under the scheme, will not also come under the principle of affirmative action adopted by courts sometimes in order to avoid discrimination. Stop. If we may say so, what the High Court has done in this case is a clear and naked usurpation of legislative power. Stop. Para. Words and phrases are symbols that stimulate mental references to referents. Stop. The object of interpreting a statute is to ascertain the intention of the legislature enacting it. Stop. Bracket. See Institute of Chartered Accountants of India versus Price Waterhouse. The intention of the legislature is primarily to be gathered from the language used, which means that attention should be paid to what has been said as also to what has not been said. Stop. As a consequence, a construction which requires for its support, addition or substitution of words or which results in rejection of words as meaningless has to be avoided.